Hi, I'm Terry Flew from the Creative Industries faculty at the Queensland University of Technology in Brisbane, Australia. I was a commissioner with the Australian Law Reform Commission from May 2011 to February 2012 and chaired the review of the Australian National Classification Scheme that released its final report, Classification, Content Regulation and Convergent Media, in February 2012. It was an unusual situation under which I came to be at the ALRC. I got a call out of the blue. I remember it. I was at the Gold Coast about to be at a lunchtime function when I got a call from someone in the office of Brendan O'Connor, who at that time was the Minister for Home Affairs, wanting to sound me out about interest in chairing this inquiry. Now, that process went on for a couple of months, and it is a rather difficult one within a university. I mean, on its positive side, I had a number of middle management roles at that time, and I was able to divest myself of those. But on the other, you also need to keep this secret because there's no appointment until the Governor-General signs off on it, but at the same time you have to renegotiate your current work tasks with your team. So while I'd become aware of this from February, I hadn't been actually able to take up the role until late May. When I arrived at the Law Reform Commission, what I found was a fantastic team, a very dedicated group of people, very smart. The quality and the capacity of the legal officers at the Commission was something that was extremely impressive. And also, coming from a university environment, I was very impressed by the sort of esprit de corps of the organisation and the way in which we worked as a team, we collaborated. It was not an ego-driven process. It was quite a shock, actually, to come back to universities after such an environment to the world of big egos and highly fragmented decision-making processes. So it was just fantastic to get that experience from time at the Commission. What was also very apparent was how respected the Australian Law Reform Commission is as an independent broker into these questions. For those who follow the classification issue, our inquiry was commenced shortly after a Senate Select Committee into the same topic had been conducting its hearings, and the extraordinarily partisan nature of that committee meant that a number of the industry stakeholders were actually quite relieved to find that the ALRC were putting their hand to this task, because they at least had a sense that whether or not they agreed with the outcomes, it was a thorough organisation in terms of its processes. So we had very good engagement with all stakeholders throughout the process. We conducted about 60 interviews over the period of time. The ALRC's formal process of putting out an issues paper for to gauge community feedback, then discussion paper, then a final report, has a great deal to recommend it. It enables you to bring out into the public domain issues that might be contentious, and the point is that if you put out something contentious in the discussion paper and it doesn't survive into the final report because of hostile views among the relevant stakeholders, that doesn't matter. It's much better to have that process take place, and we did have some recommendations that were put forward in the discussion paper that were not well received by some of the industry players, the commercial television industry in particular, so we had the opportunity to go back and rethink those. One of the biggest trends in this inquiry was the enormous amount of enormous number of submissions that we received. We received almost 2,500 submissions, 2,300 of those in response to the issues paper. The classification topic turned out to be one where there was much more engagement in the community than might have been anticipated. The issue of a 18+ classification for video games had been a very hot one, but there are also very strongly held views in the community around free speech, around censorship, around protection of children, a number of these matters. And we sought through the process to try and enact a principles-based regulatory approach, to try and gauge the sort of first principles that should inform any inquiry into the future in this area, recognising that in the context of rapid technological change in the media and convergence, that it's important not to make legislative decisions that rest too much upon particular media platforms rather than underlying principles. And in that respect, found a very, effective guiding hand in Rosalind Croucher as the ALRC chair, and also the process of engaging external stakeholders was very impressive. The advisory committee that we had was of the highest standard, and the general view was that the ALRC's final report received strong endorsement from across the political divide, that we were certainly aware that it was well regarded among those in the Labor government who commissioned the review, but also well regarded among relevant people in the coalition at that time. And if you remember 2012, it wasn't a high point for bipartisanship in Australian politics. So at this point of the 40th anniversary of the ALRC, I wish the commissioners and the team all the very best into the future. We know how highly regarded the Commission is, both in government and in the wider community, and its work is of the utmost importance. It was one of the great pleasures of my life to have had the opportunity to work with the ALRC.